Good evening, everybody, and welcome to another meeting of the All-Party Parliamentary Group for Artificial Intelligence. It's great to have you all with us, and this evening we are going to be discussing the interesting issue of AI and intellectual property rights, with a particular view of who owns the property rights when the AI itself is the creator of the work. And I think that's quite an interesting question that's been posed. And to help us explore that, we have 7 very interesting speakers to take us through their views on that. But perhaps before we get underway with our first speaker, who will be David Holdsworth, I'll just pass over to my co-chair, Lord Clement-Jones, with his splendid background in the Lords, to see if he wants to say a quick word. Tim.
Stephen, thank you very much indeed. And as you rightly say, we've got a really excellent panel here. And I'm anticipating we're going to have some disagreement between our panelists too, which is really something to look forward to. And of course, it's highly topical because it was only on the 7th of January that the government's call for responses to the consultation on IP and AI closed. Many of us put in evidence. I suspect that quite a number of our panelists put in evidence in particular. I certainly did. And so I'm going to be looking forward to seeing whether I need to rip up everything I said and revise all my thoughts on the subject. But of course, it is all about whether AI can actually legitimately be treated as the inventor for patent purposes or the creator for copyright purposes, and what the implications of that would be. And there are many and varied. And one of the big questions is whether our existing copyright and patent law actually provides for it, or whether if you did want to have AI as an owner in those circumstances, whether or not you need to actually change the law. And there are many views on that subject as well. So I'm really looking forward to this. And of course, one of the reasons why this is so topical is that one of our panelists has been pursuing pursuing applications through a number of different courts around the world, which must make life very exciting for him and probably makes IP specialists extremely nervous. So I think that we're well set for a good discussion.
Brilliant. Thanks, Tim. Birgitte, I don't know if you wanted to say anything very briefly. Obviously, the operation of the All-Party Group for AI would not take place without the support of the Big Innovation Centre, and so I'm incredibly grateful to Birgitte, to Desiree and all the team, and of course all our sponsors for allowing us to continue to be one of the most productive APPGs. Birgitte, did you want to say anything, or shall we move on to...
Well, I just want to add to just one sentence to what Lord Clement-Jones said. Clearly, patents on robots and machine learning and thinking machines, or by thinking machines, is clearly a major thing. Also, if you look at the evidence right now, these patents are fastly growing and mainly owned by the tech giants, if that have any implications. So I'm really interested in hearing from also the panel on not just about governance and ethics, but maybe also what it means for the future of innovation, competition and governance in the next generation of artificial intelligence.
Brilliant. Thank you very much, Birgitte. Right. Our first panelist is David Holdsworth, and David is Deputy Chief Executive Officer and Director of Operational Delivery at the Intellectual Property Office. David, it's great to have you with us. Please, can we have your thoughts for 5 minutes, please?
Yes, thank you very much, Chairs, and thank you to the APPG for inviting me along. The question of whether and how to protect things created by AI is not a new one. The 1988 Copyright Designs and Patents Act introduced copyright protection for works generated by a computer without a human author. But it's only really been recently that AI has really begun to affect how we create and invent things. most often as a tool for creativity and discovery, so using AI to help take photos or identify promising drugs for research, but sometimes removing human input almost entirely, with AI systems generating images, music, and literature. So in recent years, we have received claims that AI systems are not just tools, but can devise inventions themselves. So that's the really interesting change that we've seen recently. And that's the really interesting question posed to all of us. I think the government and ourselves at the Intellectual Property Office wants to ensure that AI technologies developed and deployed in the UK both transform the economy and improve lives, but by ensuring we have the right rules and regulations around AI to direct its development in a responsible way. Now, I think the challenge here, as for any regulator and any government in such a fast-moving, fast-paced environment and sector, is when is the right time and when can we get it right? Because good policy can have a positive effect, but we all know bad policy can also have a damaging effect. And in these new areas, the question is, when is the right time to take those decisions on policy and regulation, and how do you do so? And we have a very good system in the UK, as we are undergoing now, in calling for views, expertise, and then really analysing and looking at the evidence. So the Office for AI central forecast is for expenditure on AI technologies to increase from 16.7 billion to 83.5 billion by 2040. IP supports investment in technology and culture for the benefit of us all across the UK. And the UK IP system is consistently highly rated around the world. And as the IPO for the UK, we work continuously to ensure that the IP framework evolves in a way which best supports innovation and creativity. Our approach to the AI and IP issue is an example of that, where the IPO has run 2 consultations. First, a public call for views to ask broad questions about the intersection of AI and IP and to assess the lie of the land in this complex area of law and technology. And second, a targeted consultation on AI inventorship and authorship. And this targeted consultation only closed last week. We're currently analysing the responses. I'm afraid I won't be able to give you any sneak previews here because we're still in the process of analysing, and it's important we go through that process. And obviously ministers will also be involved in the decision making there. But my sincere thanks to everyone who did submit their views. We're busy assessing those as we speak. We provide patents and copyright to encourage people to invent and create new art and technology that enriches all of our lives. AI systems don't need the same incentives to create things as humans do. So we wanted to understand whether we needed to provide protection to AI creations and inventions, and actually the implications of doing so, which is why we put that call for views out, and we've gone through that consultation. Government is working hard to address some big questions in this area, and we welcome sessions like this and also parliamentarians' focus and interest in such an important space for the UK. Does it matter if the genesis of invention is human or machine? How do we incentivise investment in AI systems in the UK? Are changes needed to the UK's IP regime to give our IP-intensive economy a competitive edge in this area? And that's a really important thing for us as an IP office and as someone charged with enabling UK innovation. That's a really big question for us and for everyone here and parliamentarians. IP is vital to the UK economy. In 2016, firms in the UK private sector invested an estimated 134.3 billion in knowledge assets, of which 63.8 billion was protected by IP rights. So we recognise the importance of ensuring that the IP system develops in a way which keeps the UK ahead in AI and indeed all technology areas. So I look forward to the discussion and hearing the views of other panellists as we go through this session. Thank you.
David, brilliant. And to time, perfect. Thank you. What a great start. Very interesting indeed. And I think your enthusiasm for making sure that the UK is well placed on this is evident from what you said. I'm sure my co-chair, Tim, will have a question. Tim?
Yes, I want to follow up on exactly that point. I mean, we all welcome great language about the UK IP regime being world-beating and all this kind of thing. The question is, how much do you think we have to conform to an overall international pattern? I mean, WIPO is looking at exactly all this at the moment. Does any country stand in isolation, or do you think we have to, broadly speaking, go in step with other countries?
I think it's a really interesting question, and I think having been in the private sector as well as the public sector, the best for business is when regulation is global, and when you can standardise as far as possible. And that's why some of the great treaties we've got in this space work really well, because it simplifies the landscape for businesses. But I think it's fair to say that economies are moving at different paces. We are a technology intensive and IP intensive economy, which is great for us because it allows us to be agile and diversify. However, it does pose challenges for us. And I think the challenge for us as a regulator is ensuring that we understand the UK landscape, that we ensure that we are feeding that in to the multilateral global system, which we are doing at the moment. I was discussing with colleagues at WIPO and with EU nations and our colleagues in the US and Canada fairly recently, and that we move together where we can, but also that the UK poses its own questions in this space on the back of evidence and also drives some of the debate and discussion, which is what we're doing. So I think in short, multilateral global is always best, but you do have to sometimes ensure we understand the UK context, and we are always pushing forward the UK in this space.
Great. Well, we could all interpret that then, David. Thank you.
David, thank you. Tim, thanks. Okay, we will move on to our next panelist. Welcome to Tamara Quinn, partner at Osborne, Clarke LLP. Tamara, welcome. Perhaps we could have your thoughts for 5 minutes.
So I'm Tamara Quinn. I'm a partner in the commercial team at Osborne Clarke. We're an international law firm with a particular focus on technology. I'm based in our London office, and actually for the first time in many weeks, I'm actually in our London office as well. I specialise in intellectual property and data, and I'm also part of our AI and machine learning group. So as a sort of practicing lawyer, I thought it would be useful if I highlight some practical aspects of the debate which are important to most organisations. Firstly, I should say that as a law firm, we have no particular axe to grind in terms of us being in favour of IPR ownership by AI systems or against it. Some clients would benefit from AI having wide rights. For some clients, the opposite would be true. For many, it will vary with time or context. So decisions on whether to grant IPR rights are ultimately matters of policy, but when formulating these policies and translating them into law, I think it's appropriate for us to examine the proposals through the lens of whether the law will enhance predictability and certainty for those involved in the creation or use of the AI-generated content and inventions. Perhaps I need not say, intellectual property is a complex area of law, and I would ask that legislators don't underestimate the impact of this complexity. And whilst in theory complexity is wonderful news for intellectual property lawyers, it's obviously in some ways not so great for our clients. And organisations to whom intellectual property is important often need advice of highly specialised lawyers. It's time consuming, it's expensive, whether it's provided by in-house specialists or external advisors. And that disproportionately disadvantages organisations which don't have the human resources and deep pockets of some of the bigger players. And in practice, our clients need to understand a range of fundamental questions. Some of them are pretty basic. It's whether they can use AI-generated content or AI-generated inventions without infringing intellectual property rights, whether they can own the IPR in that computer-generated content, whether they can make returns on their investments or attract funding for innovation. And this involves knowing whether they can prevent others from using the AI content or invention, or impose conditions on them, or make their use subject to payment. And whether the approach they take is consistent with protection for AI creations in other major territories, as has just been touched on. And naturally, when formulating IPR law for AI, legislators will primarily be guided in the first instance by the purely legal considerations, existing IP law, legal theory, international developments, and so on and so forth. But there are a number of approaches which are compatible with the objective of those areas. And so I think it's incumbent on us to think about the practical effects when we're deciding which approach to take. I think it's perfectly legitimate and desirable to seek to achieve IPR law which enhances certainty, clarity, and predictability of outcome where we can. And just taking a pretty basic example. One example is a question of the type and degree of creativity which is needed to qualify for copyright protection. We currently have copyright protection in the UK for works which are created solely by computers, and the copyright is owned by the person who made the arrangements necessary for the computer to create the work. But in order to qualify for that copyright protection, the computer-generated work must be original in the sense of expressing what's normally regarded as human creativity. And this is by reference to things like exercise of judgment, skill, expressions of personality. And that's obviously an issue for an AI-generated work or other computer-generated work. How do you take that into account? It's a difficult question. It's a very difficult question. And these questions, with or without this gloss of the computer-generated aspect, are really difficult and uncertain for clients. So as I say, that's just a very basic example. IP lawyers will know there's endless examples of things like this. And it all makes it quite difficult for clients to have the certainty that they and their investors need. So I think we should ask the question, will dealing with AI-generated works in the way that's proposed when we're making the law, will that increase the amount of time, money, and effort that organizations have to devote to understanding its impact, which is usually judged by reference to whether there has been that exercise of personality and skill and so forth. And I think we should just pause and think hard before we do something which is going to increase the complexity of intellectual property law, and only do so where there's an overriding other justification. So that's really my recommendation.
Tamara, brilliant, thank you. Yes, I think we as legislators do not envy the complexity of this, and we should be listening to the experts when it comes to how we move forward. Tim, I'm sure you've got a view on that.
Yes, Tamara, thank you very much. And I think we all applaud the pause and think injunction. But I also liked some of your points about criteria by which you judge any changes, predictability, certainty, and so on. But I think it's obviously quite difficult for you with with clients with many different interests coming to a conclusion about what you would advocate in these circumstances where, in a sense, the government and the IPO need to come to some conclusions. But I think I need to ask you the question of the international question, really, because, would you say that the majority of your clients would want to see the UK forming part of, if you like, a common pattern, or do you think they're relaxed about the UK having its own regime in order to stimulate investment?
I mean, it's obvious. I'll start off by being a lawyer and saying it's obviously a really difficult one to actually give a view on, because firstly, I can't even say that most of our clients would necessarily have consulted us yet on those particular questions. And as I say, it can be very context specific, and we have a very wide range of clients. But I think it's fair to say that if we take account of advice given so far and what we know is coming up, I would say that a lot of clients, I'm not sure I would necessarily be able to say the majority, would think it was important for us to have international consistency where that's appropriate. And obviously there are going to be some cases where it would be better not to have international consistency but it's that overriding interest point, is if there's a really important reason for us to differ, which is overall going to make things better for our organizations. But otherwise, I think generally, yes, if you can be aligned aligned internationally. I think that's probably particularly important on patents, but also on content generation. I think those are important issues, and I think a lot of clients would probably prefer alignment.
Great, thank you. Back to you, Stephen.
Thanks, Tim. And again, thank you, Tamara. And we'll move on to Jason Rice, if we may, who is patent attorney at GSK. Jason, welcome. Thank you for joining us. Could we please have your thoughts for 5 minutes on this subject?
Yes, thank you. Good evening, and thank you for this opportunity to provide evidence to this group on behalf of GlaxoSmithKline. So, as you said, I'm one of GSK's in-house patent attorneys, and I support our large in-house AI ML team, part of which is based in central London, coincidentally. As most people are aware, the process to bring a new drug product to market is both costly and lengthy, and also has a very low success rate. And it's the patent system itself which allows sustainable investment in such high-risk research by companies like GSK. Now, GSK hopes its large investment in AI/ML will improve the success rate of its research, and more importantly for patients, bring new transformational drugs to market. Nevertheless, the research will still be at high risk, and so a robust and clear patent system will remain vital to a company like GSK to allow protection of inventions developed either by or with AI. As Ryan will come on to talk about in more detail, I'm sure, a recent UK court case shows that UK patents will not be granted for inventions invented by AI, not unless, of course, the Supreme Court steps in to decide differently than the Court of Appeal has done so far. And this is because an AI, in that case called Dabus, cannot be named as the inventor. A person has to be named, so the Court of Appeal says. Now, while many will doubt whether, now or in the foreseeable future, an AI is actually capable of activity which, if done by a human, would be determined as inventorship for the purposes of patent law, the Dabus case has helpfully identified a future-proofing issue in current patent law, both in the UK and elsewhere, as I'm sure Ryan will come on to talk about. Now, for an innovative R&D company like GSK, the inability to obtain patents for AI-invented inventions, if and when possible, would be a clear concern. For example, the inability to patent a new drug substance merely because it was invented by AI. Now, while GSK is not best placed as an organisation to advise on what legislative change, if any, would be best to future-proof the ability to patent AI-invented inventions, we would emphasise the importance of thorough consideration of any potential unintended effects of such changes, as has already been touched on by past speakers. However, the pivotal point for GSK is being able to patent AI-invented inventions as and when that possibility arises. Some of the options for legislative change in the recent UK IPO consultation that David talked about concern inventorship. However, we would just point out that any such change to inventorship provisions has to recognise and reflect the direct linkage between inventorship and ownership of patent rights, and that changing one could have a detrimental effect on the other if not carefully thought through. One of those inventorship options in the UK IPO consultation is to allow an AI to be named as an inventor. For this option to work, we think other changes in UK legislation may be needed, for example, to enable a company like GSK to own the patent rights to something that was invented by an AI. Now, this is because we understand the current position under UK law is that an AI as a machine cannot own and thus cannot assign intellectual property rights. Other noteworthy points for naming an AI as an inventor would be the AI used in research may not actually be owned by the company or person doing the research. This could, in theory, mean a third-party AI owner has some sort of reach-through to the patent rights created by the AI, despite not actually being involved in how the AI is used. Now, this could have the unintended effect of providing a disincentive to use AI or actually concentrate inventions in AI owners. And also touched on by others, it is interesting that the UK Copyright Designs and Patents Act 1988 deals with a similar situation in the context of computer-generated designs. Under this law, the designer is not the computer, but taken to be the person by whom the arrangements necessary for the creation of the design are undertaken. Finally, investments in costly biopharmaceutical innovation can only be sustainable if they are viable in multiple key markets. This requires international harmonization of what can be patented, including now the ability to patent inventions regardless of the role of an AI in the inventing process. We think this is an important opportunity for the UK to help lead globally by promoting and collaborating on international best practice. The UK government is therefore encouraged to work with the following organisations amongst others. The European Patent Organisation, noting the need for harmonisation between UK patent law and the European Patent Convention. The IP5, which is the patent offices of the US, Japan, Korea, China and the European Patent Office. The World Intellectual Property Organisation, which itself has its own ongoing consultation on AI and IP. And finally, the World Trade Organization, noting the WTO agreement on trade-related aspects of intellectual property rights. Thank you very much.
Jason, thank you very much. And also thank you for bringing alive the challenges you as a company face. I think it helps bring it into sharp focus. Tim, I'm sure you've got a comment.
Yes, thank you very much, Jason. And thank you for making it very clear about where you stand on the international aspect of it. I'm sure David has made a very careful note of all the organizations that we need to align ourselves with. But I wanted to ask you about the Dabus case, actually, and it's quite convenient that it comes before Ryan has his say. Were you surprised by the outcome? Not so much on the question of ownership, but on the question of inventorship. Did you find it surprising that it, with the exception of Lord Justice Warby, that's where the court came down? Because you know, there are some people who say that, including myself and Christian Gordon-Puller, who co-wrote the our submission, we thought that actually that was a slightly surprising outcome, and we thought that Warby had got it right, actually, and that's what we hope the Supreme Court will confirm. Where did you stand when you were advising internally? Did you think that it would come to that?
I'm going to do the classic attorney thing and sit on the fence. I don't think we had a firm view either way. I mean, I think it's been interesting to see how this case has played out internationally, which has been very helpful, and to establish that there is no general consensus on this point. Obviously, the US, European Patent Office, I'm not sure about Japan, but they tend to have sided with the UK decision, or they've all come to the same decision, whereas in Australia and South Africa, they had no issue allowing the AI to be named as an inventor in those patent applications. I think from our internal considerations, it was more waiting to see what the decision is and what the potential ramifications would be. And so even if, for example, the Supreme Court did take this case on and reverse the decision and give comfort for people, I guess we still, as a multinational company, got the spectre that other important markets for a company like GSK, the US and the European Patent Office area, will not allow an AI to be named as an inventor. You know, as and when the situation ever arises that an AI should be named as an inventor. And I guess that's one part of the Dabus cases that, you know, there are comments on, is that's never been interrogated at all in any of the cases as I understand it. It's just taken as a given, or not necessary to investigate whether the AI should be named as the inventor, or whether at least one human should also be named. But yeah, for good purpose, which we're all benefiting from, including conversations like this.
Yeah, thank you very much. And I should point out, as Christian has, to me, that it was Lord Justice Burse, not Lord Justice Warby. I've been looking at two different cases, one on surveillance cameras, and that's Warby, and the other one is this one. So it shows how AI links everything together. Thank you very much indeed, Jason.
Thanks, Tim. And again, thank you, Jason. Right, we are going to now go over or back to Ryan, who hopefully we will both be able to hear and see. Ryan.
Lord Clement-Jones did tell us that we were going to have a contentious evidence gathering session today. I don't think he anticipated it would involve IT as much as it has, but I am glad I could at least be disruptive to the group. And I did have a moment of panic when he was talking about what Justice Warby said about the case, but I'm glad we've resolved that. I did have an opportunity to submit some written evidence in response to the 3 questions the group was asked. And so in the spirit of somewhat of a discussion, would like to try and weave in some responses to what people have said, starting with David's comments. I would like to disagree with them more. I'm not sure I can disagree that much, but I think he makes a very good point that these issues have been with us for a long time, and the UK was one of the leaders in establishing protection for computer-generated works and copyright in 1988. Now, there hasn't been much litigation about that, I think for a number of reasons. There's only one case I'm aware of, and even their subsistence of copyright wasn't being disputed. In part because you don't register copyright in the UK, and copyright infringement cases aren't that common. And even where they are, this law makes clear that subsistence would be a hard thing to challenge. But it has been more or less a toy problem for a long time, in that while AI has been making things, they haven't really had any commercial value because they've been terrible, because the AI hasn't really been very good at it. But now AI is routinely making things, that would be copyrightable if a person made them, from NFTs and digital artwork to galleries of AI art that you see springing up across London to, short stories written by AI. And so while these problems are in some sense old, the commercial imperative to get it right now is really very critical. And that's the case with AI making new inventions also. It may be that machines like DABUS aren't common throughout, many industries or any right now, but this is the time to have the right legal frameworks in place, because this is the time that companies like GSK are making very substantial investments in building and using and operating these AI systems. And if you were to wait 5 or 10 or 20 years to be having these sorts of discussions, you would risk companies losing a tremendous amount of, the ability to plan for innovation in the future. David made a good point. Intellectual property laws are really only to benefit people, of course, but one of the ways that people benefit, through particularly the patent system, is from the creation of new innovations. And as AI has gotten better than people at doing things like playing Go or predicting protein folding structures, AI is going to get better than people at inventing certain sorts of things. And of course, a machine doesn't need a patent, but building and using these AI systems is a very resource-intensive activity. And if what the current state of the law says to a company like GSK is, if you could build an AI to find a new COVID vaccine, if you really need a patent on that, don't bother. You will have to use teams of people, because if this comes out of an AI without a traditional human inventor, there's no way to protect that sort of thing in a way that allows for effective commercialization. And I think that is a fundamental mistake if we believe in the patent system as a system of innovation, which has served the UK well, and where the UK has been an international leader for many years, to exclude an entire category of innovation from protection like that. Birgitte mentioned big companies, and they may have an outsized role in making investments in this and owning this sort of thing. That is a feature currently of the economy, that large enterprises own a lot of resources and own a lot of patents, and it is how we have decided that things work most efficiently. There are competition concerns sometimes, and there are distributional wealth concerns with something like that, but there are mechanisms for dealing with that sort of thing, much as we discussed in our data evidence session through, competition law and really tax law, to the extent that we're concerned about big companies owning too much. And there are protections built into the law, like compulsory licenses for when patent holders abuse systems. Though DABUS in our case, and we could talk about that, did invent this without what would be traditionally an inventor under US or UK law, and that was interrogated in Australia, but not otherwise. And otherwise, patent offices don't normally interrogate those sorts of comments. It's never been our contention that the AI should own a patent. An AI can factually invent something in the absence of a traditional human inventor, but it isn't a legal person. You could give an AI legal personhood, and maybe that wouldn't be as strange as some people make it out to be. For example, a self-driving car and an insurance policy. But there's really no way that works better than having the AI's owner or the person controlling the AI owning its output. If I own a 3D printer and it makes a beverage container for me, I own that. The machine doesn't own it and then transfer the title to me. A fruit tree doesn't transfer me title to the fruit that comes out of it. I just own that because it's my property, right? And for the same sort of way, even though Davis may be a legal inventor, it is not a legal person. It doesn't have legal rights and obligations. You know, it makes output at my urging, and I own that output. And that is a system that will encourage the AI industry and the pharmaceutical industry and many industries in the UK to build these machines that are going to make innovation that's going to benefit everyone. You know, to the international point, I think the right answer is for the UK to decide what the right law is for the UK and to promote that on the international stage. But you can already have different standards right now in what makes someone an inventor. So you can have different inventors in the US than in the UK, you know, based on claim and specification drafting. And here we already have jurisdictions, some of which are going to allow an AI to be an inventor and some of which won't. Although everywhere where, other than South Africa, this case is still currently under appeal or still alive. So we will see what happens at the end of the day. You know, but ultimately, I think the UK should decide what is the right law for the UK and advocate for that on the international stage. Different countries have different interests in this, but the UK is both an IP exporter and hopefully going to be an AI global power. Not every country is in that same situation. So that takes me to 5 minutes, and I will keep to time.
Brilliant. Thank you very much indeed, Ryan. That was worth waiting for, obviously. I'm very keen. I think the two messages that come out for me are: don't rush, but don't go too slowly with this. We haven't got time to hang around, but we need to get it right. And the other is, I think your final point was, you know, try and see AI as a tool, a very clever tool, a very creative tool, but it's still a tool at the behest of someone else, and that may help clarify thinking. But Tim, do you have some thoughts?
Yes, thank you, Stephen. And thank you, Ryan. I mean, really interesting. And again, I think David is going to have food for thought from what you said about the need to move forward on this. But, you know, as I see it, with your most moderate hat on, what you're really saying is align patent law with copyright law to a degree, by saying that an AI can invent just in the way that it can create, and then the ownership, it belongs to the human, well, either owning or operating it. We haven't really talked through that at this stage. But you've also argued that AI systems should have actual rights, haven't you, Ryan, as well? Or are you saying that it is purely a tool in the way that Stephen describes?
Right, thank you for that. So we've never argued that an AI should have rights, you know, akin to a company or a person, right? That an AI would be a legal inventor, but never that it would be able to own property, right? The property would go to the people owning or operating the AI. That is indeed a whole important discussion that may be a little nuanced for today. You know, but really with the moderate hat on, the question is, how do we use AI to best benefit society? Right. And we do that if AI can invent, by letting it invent, by encouraging people to have it invent, and by ensuring that you can protect that sort of output, because that is an incentive mechanism that we use to commercialize new inventions, promote disclosure of information, and to innovate in the first place. You know, on the tool front, very briefly, you know, you can now go to a variety of open source commercial applications, put a couple words in, and an AI will make a new piece of artwork or article for you. You know, it is doing what it is that a person used to do that made them an author. Now, if you want to think about that as a tool, right, in some sense, of course, the AI is just doing that because you ask it to do it. But it really is automating a human behavior that you wouldn't think about, you know, in that sort of sense. You know, it's really very similar to what a company like GSK does when they have a research scientist find a new drug, except instead of saying to a team of pharmacologists, go find a new COVID vaccine, you're going to an AI or a bunch of people operating an AI and saying, go find a new COVID vaccine. And either way, the argument is really that the company should own the property from that.
Thank you very much, Ron.
Brilliant, Ryan. Thank you very much indeed. Can I just remind people to use the Q&A function when we get to the question and answer session. So drop your questions in. Okay, we will move on to our fifth panelist, which is Dr. Faye Wang, Senior Lecturer in Law at Brunel University, London. Faye, welcome. Thank you for joining us. Please, may we have 5 minutes from you?
Good evening, everyone. It is my honor and pleasure to be here today. I'm Dr. Faye Wang, Senior Lecturer in Law at Brunel University. With an educational background in law and computer science, I have been a law academic for the last 18 years, specializing in cyber law, considering how law is challenged by the innovation of technology in both common and civil law systems. Today, I would like to share my opinion on whether AI technologies should be granted status as owners and whether AI-generated work should be subject to copyright protection. I believe removing the legal uncertainty on these two issues are crucial to further promote AI investment and invention in the UK. In order to grant an AI algorithm as an owner, the law would need to recognize its legal personality. Although advanced AI may be able to perform human tasks via deep learning, AI currently does not have emotions. It could be argued that if AI algorithms could have human consciousness, they should be given legal personality. However, this is not happening in the foreseeable future. One of the most common analogies to compare it to the most common artificial person, a company. Granting an AI algorithm as a new legal person does not appear to be necessary if there is already a legal person, such as a company, which could be responsible, or if there are human contributors who could be attributed to such algorithm. There is currently a growing trend of consensus among jurisdictions that an AI algorithm should not be granted legal personality, such as in the EU, US, and China. In any case, AI-generated work should be subject to IPR protection to encourage technology, innovation, and investment. The recent AI and IPR report in the EU confirms so in that copyright to AI-created work should be granted to the natural person who prepares and publishes it lawfully. Also in 2019, a Chinese district court held that an article automatically written by a robot software should be subject to copyright protection. In the UK, copyright legislation already recognizes computer-generated work, which, in my opinion, should be interpreted to include AI-generated work. Currently, New Zealand, India, Hong Kong, Ireland, and South Africa have similar causes of computer-generated work in their legislation. However, Ireland has 20 years longer than the UK in such protection. One of the challenges of protecting AI-generated work in copyright would be when a human may not be identified for AI-generated work in copyright. If machines can learn and produce work from each other, those AI-generated works in copyright may not be able to be attributed to specific owners, because it would be very difficult to know the proportion of actual contribution to the creation of work. In such a situation, legal and technical mechanisms should be established to determine humans who make primary necessary arrangements for identified primary AI algorithms. The same analogy may also apply for AI-devised invention in patent protection. Pursuing UK national AI strategy, UK should devote more efforts to develop regulatory and non-regulatory guidance on AI and IPR. In my opinion, the UK should make no legal change to current copyright protection concerning computer-generated work, as this clause is terminological and technological neutral and could adapt to any anticipated technological change. However, as new technologies developed, supplementary regulatory interpretations to IPR legislation is required. For example, the application to the current legislation to AI-generated work should be further interpreted to bring about legal certainty and strike a balance between the protection of rights holders and the incentives for technology, innovation, and investment. AI-generated work should be granted IPR protection. The most appropriate persons for such protections are humans who make primary necessary arrangements, including the creator, programmers, developers, and designers for identified primary AI algorithms, the person who select, input, and train the data, and the operator and users of AI algorithm. In this regard, UK could set out an initiative to promote international harmonizations on IPR protections for AI-generated work. Thank you.
Faye, thank you very much indeed. Very, very interesting take on that. Tim, I'm conscious of time, but
yep. We're speeding through. Faye, I just really wanted to say thank you because you've raised the copyright area as opposed to the patent area, which I think is of equal interest. And in a sense, what you're saying is that you would hope that there would be sort of international standardization almost based on our own copyright law here. But there are some people who argue that once, we have really everyday use of AI, things like GPT-3 and so on, in terms of creating narratives and artworks and so on itself, and maybe under the sort of overall aegis of a human being, but basically they're churning out works through AI, that there should be a much different term of copyright, that 50 years is far too long in those circumstances, let alone, the human in copyright of 70 years, etc., plus life. But I mean, where do you stand on that?
Thank you very much. This is a very interesting question, Lord Clement-Jones. I think I have think about it before as well. And at the beginning, I was thinking maybe this need to be reduced to 5 years, but I was thinking about actually 50 years is not that long, considering that this is already much shorter than solely human creation work, because now the copyright for natural person was the death of 70 years after the death of the person, and now it's only 50 years after for the computer generated work. It will only be protected after 50 years of its publication. So it's already shortened. So it is a very fine line to trade off the balance about whether you would like to encourage more of people to invest on AI investment, innovation, to have AI generated work, or you would like to protect more human creations, etc.
Thank you very much, Faye. Some people might disagree with you about the length of it. To Jeff Bezos, 50 years may seem like a very short period of time, but for some people, it's quite a long time. But there we go. We can come back to that. Steve.
Thank you, Tim. Right, on to our penultimate panelist, which is Scott Roberts, Head of Patents at BT. Scott, welcome. Thank you for joining us, and we very much look forward to hearing what you have to say.
Thank you, Stephen. So yes, I'm Head of Patents at BT. I've practiced as a patent attorney in the field of computer science for over 20 years. And my IP expertise is in the area of inventions and law of patents. So I'm afraid I'm going to regress to that topic. My submissions come from the perspective that inventions generated entirely independently by AI cannot be patented in the UK, according to the recent Court of Appeal decision, and that this is a less than ideal state of affairs. According to patent law, the person entitled to the grant of a patent for an invention is the inventor. And for this reason, for us to discuss anything to do with the ownership of patents for inventions necessarily requires an analysis of whether an AI can invent. And it's really noteworthy that there's little consensus on this issue, whether an AI can invent. And that's part of what I want to discuss a little bit here. In UK patent law, the inventor of an invention is defined as the actual deviser of the invention, but devising an invention is a multifaceted exercise, recognizing a problem to be solved, arriving at an inventive solution to the problem, and recognizing the efficacy of that solution all really constitute part of the process of devising an invention. But a person who is an inventor need not undertake all of those stages. It's quite possible for a person to just solve a problem that was given to them and where the efficacy of that solution was tested by someone else. To understand the role of AI in invention, it's worthwhile considering a very simple scenario. So a person presented with a problem and the state of the art may generate a novel solution to that problem. And that solution may be an invention, and the person would be an inventor. It's not really relevant how the solution was arrived at. It may be some magical spark of invention. It may be a very lengthy hunt for a solution, or it might just be serendipity. It's still an invention all the same. And given sufficient time, paper and a pen, the person who invented could even adopt the approach of a computer. And with an enormous amount of time and a vast amount of ink and paper, they might even adopt the approach of an AI, because essentially all AI is inherently computable. Now, replacing the pen and the paper with an AI affords the same outcome for the inventor with greater speed. The AI takes away the legwork from the person, but it's still the person who solves the problem, employing the AI as a tool. Now, in future, it is conceivable that an AI devises an invention entirely independently without being used merely as a tool, and this is important to note. For example, as has been discussed by our colleague from GSK, in drug discovery, AI is already able to assess the efficacy of its own discoveries through modeling and simulation. For an AI to be acknowledged as the independent deviser of an invention, the AI needs to elevate its contribution above that of a mere tool. So the AI needs to subsume at least part of the role of the person by either recognizing the problems to be solved or indeed the efficacy of its solutions. And this constitutes a higher standard for inventorship for non-persons, but it is justified because the starting point for defining the role of an AI as a tool is that it is a tool. And any departure from this position must mean an elevation of its contribution above that of a mere tool. So on the point of whether AI can invent, in short, I think it would be remiss to consider invention as beyond the capabilities of AI, certainly in the medium to longer term. AI will invent, and the IP framework must adapt to provide protection for those inventions. Protection is not available today. Otherwise, industries that depend on patent protection to secure their long-term investments would be undermined, such as some biotechnology industries. And it's in this context where AI generates inventions that I want to talk about my second point, which is the need for clear rules around ownership of AI-generated inventions. It's really tempting to arrive at some straightforward rule, such as the owner of the AI owns the invention. But unfortunately, there's much more complexity than this. The AI system can be provided as a service, can be leased, can be shared or commonly owned. The AI code may be licensed, maybe even be open source licensed, and the data on which it's trained may or may not be owned by multiple different parties. And these all add incredible complexity to the question of ownership of the output of the AI. There's no easy answer on ownership. I don't strongly disagree with any of the representations that have been made today on ownership, but I do say that there's little value in generally assigning legal personality to AI per se, not least because its owning or operating organization will already have the requisite legal personality. Very last point I want to make is the most important point, I think, for policymakers and parliamentarians. Patent law needs to adapt for the reasons I've discussed, and that adaptation must take place in an internationally harmonized way. Currently, patent protection for AI-devised inventions is not possible in the UK and a number of other jurisdictions, and whatever solution is adopted to correct the situation and deliver the necessary protections that incentivizes developments of this really important technology must take place harmonized internationally, and it's my strong recommendation that further discussions are held multilaterally across jurisdictions with the World Intellectual Property Organization with a view to agreeing a harmonized approach. Thank you.
Brilliant, Scott. Thank you for that. Fascinating. I think there is a real common theme. There may be some differences, but the common theme is obviously we do have to move together internationally and get that harmonisation. And I'm sure that we'll probably agree that there is a leadership or a role for us to play in that. So thank you. Okay, on to our final speaker.
I'll just, if I may,
sorry,
Stephen, just I don't want Scott to feel neglected.
No.
Scott, just thank you for those 2 stakes or a couple of stakes in the ground there, very important. But I wondered, you sort of glided over the point about licensing and operating and so on as to where the ownership would fall if an AI system is used. And I wondered where, for your money, you would place the ownership. Is it on the person who operates or licenses the AI system, or is it actually the company or legal personality that actually owns the AI system, that actually invents?
For my money, I see great benefit in the approach of the copyright provisions. And so we would be looking more to those involved in operating and using and being involved in the operation of an AI as being the owners of its output.
That's very helpful. I mean, it does sound as though we're trying to almost align patents with copyright as we go forward. Thanks, Stephen.
Right, thank you, Tim. Okay, and on to our final speaker, which is Professor Joanna Bryson. Welcome. Joanna is Professor of Ethics and Technology at Hertie School in Berlin. Welcome, thanks for joining us, and we very much look forward to hearing your contribution. 5 minutes, please.
Well, thank you very much for having me. I have to say that I am an expert in artificial intelligence and also in legal personality for artificial intelligence. I am not an expert in IP, although I did have to teach that to undergraduates at University of Bath for 15 years. There's a mandatory in UK law lecture for computer scientists that we come to understand IP, which is interesting. And I was wanting to give it. Anyway, I had a set of things I wanted to say, and now that we've sat in this meeting, I think that I'd be better off if I leave them out and really come back to talk about the consensus. I don't think the consensus here is only about international alignment. I've heard already a strong consensus that there's absolutely no utility to talking about legal personality for AI itself, but also I believe I've heard a strong consensus that we should be thinking about the fact that AI can produce, is what I've heard, in inventions. So I think the main thing that I can do to make a contribution here is to just try to slightly clarify that language and say that it isn't that the AI that the AIs are making stuff. It's that we're producing our innovations through using AI. Right? And I think that's the main problem that hasn't been made clear. So I will give you a little bit of the talk I was going to do. I'm from Chicago, if you can't tell from my accent. And there's a fantastic street photographer there named Vivian Maier. And very much like Emily Dickinson, she did her entire oeuvre and then put it in a trunk, in fact, several trunks, and then died. And then someone found it. But Emily Dickinson was a poet. And so it was done. You know, people could release it. When Vivian Maier's work was discovered, it was mostly not even developed as a photographer. And so then other people developed it and chose how to crop it and all that stuff. And consequently, museums refuse to show it because you're supposed to have end-to-end on a single person, or else it's not art. And that's complete fiction. Go watch a movie about how contemporary art is made. There's one person that's like nominally in charge of it. But there's huge, factories of people, and that's been true for centuries, factories of people producing these paintings. So I think the important thing to realize about artificial intelligence is it is another part of the business process, and it is amazing. It's decentralizing. I loved what was been said about GPT-3. It is never true that AI is producing work without human intervention. AI is itself an artifact. Someone wrote it. Okay, so when you see that, oh, I only said 3 words and I got this painting, there was massive human intervention before that painting came out. You just didn't see it because it was back when the people were training and building the AI. And so, in fact, you could even argue that our entire culture that came up with the concepts of art that were then used to train it is also part of that production capacity. So what I think is happening is, as a part of the information age, a lot of the old contradictions and shortcuts and what computer scientists call heuristics for assigning and attributing credit and blame, it's becoming clear that they're slightly fictions, as all legal personality is a fiction. And I think now we just have to not say, not further complicate, and I love some of the things people have been saying before, not further complicate IP law by trying to add in another thing, which the problem with legal personality for AI is it's the ultimate shell company. It literally doesn't care, right? So it doesn't make sense at all to attribute ownership to AI, except as a way to let corporations off the hook for liabilities and things like that. So what I think we should be remembering again is that AI is itself an artifact. The law is an artifact, but the law is an older and more complicated and more kind of crunchy artifact. And the AI is new and digital. So let's write the AI such that we can best implement and maintain the existing law. And let's mandate that we have transparency through the process. And yes, people are going to say, oh, but I wrote that AI. I guarantee you what will happen is probably people like Google will come in and say, we want our 3% or our 50%, whatever they're going to come in. But there's going to be contracts written about, okay, if you're going to use this data set or if you're going to use this AI, then we get this proportion of the IP. But absolutely, I don't know what you legislators do try to maintain the concept of IP so that the money can keep flowing. But don't make it too much about emotions and consciousness for the machines. Forget that. You do not want to motivate the construction of AI that's hard to understand. You want to motivate the clarity and most transparent stuff you can have. And so therefore, do not give special benefits to things that are opaque. Give special benefits to things that are transparent and say, you guys are doing it right. And those are the people who should be rewarded.
Brilliant, Joanna, thank you very much. Indeed, some very interesting and salient points there. Tim, what would you
final roundup, Joanna? Thank you, because you've given shape to all of this, and I love your statement about personality as a fiction. We lawyers love fictions. The whole of life is a fiction, really, in legal terms. But thank you. So you have no fundamental objection, actually, to aligning what we've talked about, patent law, with copyright law, where the AI is still a tool, but but the ownership is with the human that deploys it, in the same way as we've talked about. You talked about the film industry and so on. But what happens when we get artificial general intelligence, when actually AI will be training itself, inventing other AIs and so on? Or do we just hang around and wait till that comes down the track?
Okay. I would basically say that isn't going to happen. And so therefore you can do whatever you want when that does happen. Or you could say you're going to do whatever you want when that does happen. But I would say there's a difference between IP and copyright, and that might be very important in this context. And that is about the duration. And a lot of us in the software industry have thought that the duration of patents is much too long for digital artifacts already. I think a lot of the problems that have been happening in publishing and this whole mess around, pay to publish and everything that's come out of open. If you just said, okay, you can charge for a publication for 6 months, then the publishers would stay active and feasible, but then everybody could have free access to things. So I do think that shortening the duration of IP ownership might very much be a solution, and you don't want to go to the direction of whatever the lifespan is. That is the over-identification. And one of my co-authors, Michaelis Diamantis, has talked a lot about the over-extension that's happening in the United States law right now of taking this fiction of legal personality and then using it as a means for corporations to evade because they weren't compos mentis because they didn't keep records or something. Yeah, don't do that.
Yeah, that's really interesting. Thank you very much.
Thank you. Now, I can see that, Ryan, you've got your hand up. Did you want to make a comment on something before we go to the questions?
If I could briefly respond to what Joanna and Scott said, I thought they were really great comments, and I wanted to offer maybe a little nuance in the way that we're thinking about this, and circling back on this tool issue. I think the challenge here is that, you know, AI, I think we're all agreed, shouldn't have rights, doesn't have legal personality, but I don't know that thinking about it in a tool is the right way to think about it, unless you want to think of an employee as a tool. Because really what we have with this AI is automating human behavior, even though it is not a person. I mean, yes, there are people all over the place, as Scott said, building the AI, telling it to do things, interpreting the outcomes. But in some of the applications, you know, where AI is doing these sorts of things, there is no one who is selecting the problem to be solved, or the output of the AI is obviously valuable, or there are very large teams of people who are training it to do, you know, not general AI, but certain generalized problem solving, like optimizing industrial components. And so the challenge is that the thing that used to make someone an author or an inventor is now being done by an AI in a way that is not directly reducible to something that a person does. And the commercial issue here, like with copyright, is, well, can we protect the output as IP, right? And that's the big commercial issue. But there is also a reason in the patent law, and maybe even in copyright, why you would want to list the AI as the author or inventor, because it is really the AI that is doing that rather than a person who is taking credit for work that they haven't done. And, you know, as Scott mentioned, inventors own their patents. Well, actually not in the UK. Actually, the first owner of a patent in preference to an inventor is someone who has the right to an invention, usually through an employment contract, but through virtue of any rule of law in the United Kingdom. And so actually, right, if I own that 3D printer that makes some new design, common law rules of property ownership should suggest that that is owned by me, even though the AI made the thing. And so I just wanted to offer those thoughts.
Brilliant. Thank you, Ryan. Okay. Whoops, where are we? We'll now go to questions, and I'm just trying to bring up, there we are, chat. So the first question is going to be from Tim Pickering. Tim, welcome. Sorry, Tom. Can't see properly. Tom Pickering.
Yeah, I listen to these conversations primarily because I'm interested in the psychology. I'm a business turnaround expert, and psychology is all about business turnaround, or the other way around. And I just wonder whether or not we're creating impossible problems that we're unable to control. And there's some elements of critical thinking that I think are worth considering. So, first of all, is the sort of context of creating IP and the sort of future plan of the metaverse and the context of that, keeping tabs on, you know, ring fencing IP, the transparency of its creation, because, you know, traceability with, you know, where does it come from, the sheer volume of these inventions, the speed at which they're created, and the sheer complexity. You know, not to mention that, you know, what extent does a person take credit for it, which I think is a bit secondary, because I think the sheer volume of these things is going to just get completely overwhelming. And I think actually the sort of question over IP as being a snapshot of value is going to be increasingly valueless. And I don't know, if I was working in the patent's office, I'd either be very worried or very excited. I'm not sure which, in terms of being able to keep tabs on this. So I think there's some really critical thinking that really needs to take place in this. And I really do think we're creating an unmanageable situation. We're talking about, you know, some of the details, maybe while Rome's burning, when in fact there's a much bigger sort of question here. So I think that the interesting thing is actually involved in turning around a business that was actually quite clever, actually. It was an AI-based business for actually catching people for IP infringement, which is a great application of AI, but that's very much the other way around. But I think we're undoubtedly going to create a situation whereby AI, from a psychology perspective, AI is the answer to this impossible problem if we're not careful. And that is, in my view, not healthy psychology. So but there's a few observations from the psychological perspective of this discussion.
Thanks, Tom. I think, Joanna, you've got your hand up, and I think Birgitte wants to make a comment as well. Joanna.
Okay, thanks. So that's actually a great question. I love bringing up this volume thing. And it also comes back to what I wanted to do, which was to reply to the reply to me. you know, AI, do you want to say it's a tool? The employees are often treated like tools. One of the points I was trying to make with the Meyer example is we all have heard about, like, you know, the Edison labs, things like that, where thousands of people were involved in these innovations that are then attributed to a small number of people through some weird process. We are in the information age now. We can have thousands of inventors and we can figure out how to diffuse the payment across them. We don't have to do this kind of fiction anymore if we don't want to. I agree there's a complication thing. There may be a thresholding about what is actually worth copywriting, although everything's sort of automatically copyrighted, right? So as soon as it becomes a value, you can go back and see who innovated it. Again, we have digital records. We can do those kinds of comparisons. But yeah, I absolutely do not want to say that AI is ever equivalent to an employee, because the whole point about human rights is that we're defending these fragile entities, which are the point of our entire existence and culture, right? And so it's not that, but it is certainly true that industrial processes and the law sometimes can turn people into things like tools, and that's unfortunate. And that's something we should be working to get our heads around and capture these kinds of complexity problems.
Thank you. Birgitte.
So I said, I'm not a lawyer or philosopher. I have my background in economics. And there we're also talking about the public domain. And what about the rights of the public domain? And I just want to put that in here because we from economics talk about it more like a utilitarian perspective of the intellectual property rights system. And now, of course, you have the Intellectual Property Right Office here today. So I think that the utilitarian perspective and the issue of privilege versus rights have to be addressed. So when we're going through the whole issue of IPR on human genes or stem cell research and genomics and mathematics and software, and now we come to artificial intelligence. So from what economists would say, they would start with what does the right do for society? What happens to the public domain? What happens to creativity, innovation, the social origins and everything we do, economics and social welfare? And I think these are some of the things we need to address. What do we want the IPR system to do? That's what the economic philosophers did historically, and that's where we should be starting. And I hope that's also where the Intellectual Property Office is starting, and also understanding that because a machine can do something, it doesn't need to own it. We have something we call the public domain. We all build upon it, as well as ideas, as well as creativity, as well as knowledge, and we should continue to do so. And the tools that can help us to do so should be there. And AI is certainly an amazing tool, and we need to ensure that that is also put into the public domain to what extent that it drives welfare.
Great, thank you for that point. I don't know if anyone wanted to answer back on that. If not, we can go to our next question. Did you want to comment, Joanna? No. Yes? Go on then. Or is that just saying yes, hands up?
No, that was a thumbs up. I was just totally agreeing with what she said. I think that the ultimate diffusion of accountability is through public domain. So I absolutely think that should be something that I'm glad somebody brought it up. Okay, great, thank you. Right, so, Tim, did you want to?
Maybe just very briefly to comment on that. I think Birgitte got it exactly right. I mean, what you have now is this new phenomenon of machines stepping into the shoes of people and doing human sorts of things. And this really requires policymakers to think, you know, what is it we want out of the intellectual property system? And now that this is happening, what rules are going to get us there? Not just, well, someone in the 1950s wrote that an inventor needs to be an individual, and that could only possibly mean a natural person. And I think really what you've heard from this group is that we do need this incentive there to encourage the sort of activity that it does result in more innovation from people, and that the way you get that is by protecting this sort of innovation, and for a variety of reasons that listing an AI as an inventor would have some benefits without, you know, giving it legal personality.
Great, thank you very much. Right, we'll go on to our next question, which is from Shirin Sheikh Bahai.
Yes, hello. Thank you very much. Yeah, it's a brilliant session. Really appreciate it. Well, I'm an educator and I work with a group of AI specialists in the field of educational resources. And since the intervention of individuals, like as a team, will decrease with time when it comes to AI as a learning machine, I was wondering if the AI-based products such as games or educational resources, when it comes to patent application, which is designed by more than one person, like a team, are going to be registered under a single computer-generated IP, or the right of the inventors are going to be reserved as individuals?
Who would like to have a crack at that?
So I think on that, hi, thank you, Stephen. So I think on that, that's one of the things we're exploring at the moment. So I think at the moment, different companies, based on their product and based on the advice they get from their professionals, will adopt different approaches to this dependent on the IP jurisdiction they're registering it in. But what we're looking at going forward, and as part of the call for views, is does the way this works, can we simplify it? Are there changes we should make, given, as we've talked about, the volumes that we're going to face with AI, etc., and some of those more legalistic challenges in this space? Should we change? Do we have to change? But I would say at the moment that it is very much driven by a company's own policies in this space and by their professional advisors. We do have AIs that are currently being granted patents. We do have tools out there. We do have products coming out, and dependent on the IP strategy of the particular firm will depend how they're currently using the IP framework.
Thank you very much. Very helpful.
Thank you. Right, next question I think is Sylvia Lahanis.
Thank you very much, Stephen. Hi, good evening. So I'm the head of data to digital consultancy, UBDS. Really pleased to hear from the diverse panelists today. And many have mentioned the need for IPR to be considered at an international level. So my question is, where are those critical conversations happening at a multilateral level, and what upcoming legislation can we expect?
Yeah,
I think as the regulator and registrar, it's probably appropriate for us to respond in this space. Well, I'm pleased to say there are conversations ongoing at the World Intellectual Property Office that the UK continues to be part of. So that's one of the good things there. And WIPO has recently conducted a survey of member states' views in this space, and there are potential for further discussions. The European Patent Office, of which we are a member state, is also looking at convergence of practice in this space. So in some of these areas, what we do know is it's not always a legalistic question, it's a question of practice and how offices approach practice under current existing treaties, and how can we ensure we take a harmonized approach, if you like, or something as simple as updating our guidance to enable people to navigate some of the complexities in some of the IP space. So we're having conversations both at World Intellectual Property Office level with the European Patent Office, but also we are having conversations at a bilateral level, as I said, with countries like Canada, the US, New Zealand, Denmark, where we know because of our economic interests in this space and where we are as jurisdictions, our interests are at a stage in the journey where we know we want to be having a look at this, and we want to be preparing and making sure that the IP framework meets the needs and really encourages innovation, because that's what the IP framework is there for. It's there to reward, encourage and enable innovation, and it's important we as regulators ensure that it always remains fit for purpose.
Brilliant, thank you. I think we are very nearly out of time, so I'm just going to pass to Tim for perhaps a couple of words, then Birgitte, and then I will wrap things up. Tim.
Thank you very much, Stephen. Well, I wanted to add my thanks to the panelists. We've really covered the waterfront in this, and I hope that a lot of us will go away with quite a number of the issues clarified, and the clarion call from David that the IP system should be all about innovation, or to encourage innovation. And Birgitte's point, I think, about the economics of it, I think need to be very clear. But I also believe that actually human endeavor itself needs to be valued. You know, there are a lot of movements out there in terms of not quite a reaction against AI, but certainly insisting that as part of any set of ethical oversight of AI, there needs to be humans in the loop. And I think that applies as much to IP as it does to all the other ethical aspects, such as accountability and transparency and so on. So I don't think IP is an outlier in that respect. I think it's very much part of the debate and discussion that we need to have going forward about AI governance. So I say to David, do talk to the Office for AI. I'm sure you do. But I think we need to be holistic about this, not just simply carve out IP from the rest of it. Thank you.
Thank you, Tim. And perhaps a word or two from Birgitte.
Yes, so I just want to say also that I want to add that it's not only, of course, well, the IPR discourse is really extremely interesting and we want to continue to do this, but now we're on the all-party parliamentary government AI pavilion. We have the program for the next 2 years. Everybody can download. They can also download all our reports and everything which we have produced. And when I say we have produced, we have had amazing support from Dr. Desiree Remmert for the last couple of years. But this is Desiree's final meeting on this side or on our side for the APPG AI, because she's now moving on with her next jobs and roles in her amazing career. I'm sure we're all going to be meeting Desiree again, but we were extraordinarily happy to have you, Desiree, and like I think I speak for everybody, have Desiree around during the lockdown period and the period up to it. So you will see a different program director moving forward, but we wish clearly Desiree success and hope that she will keep joining our meetings.
Thank you.
Yeah.
Indeed. And I add our grateful thanks to you, Desiree, for all you've done for us over the last couple of years on behalf of the APPG AI, on behalf of myself and Tim. It's been a pleasure to work with you, and thank you so much for all you've done to promote the group. And I wish you, I'm sure we all wish you the very best of luck in your next challenge. But hopefully we will see you. We will see you from time to time. Can I therefore wrap up and say a huge thank you to our panelists this evening, to David, to Ryan, Tamara, Jason, Faye, Scott and Joanna. Thank you for your varied and very interesting comments, all of which will have been gathered up and form another report for us. An important piece of work, of course. And can I thank all our audience and all our questioners, everyone really, for making this such an enjoyable and informative session. I hope to see you all again soon at another one of these. Until then, have a great evening. Thank you very much and goodbye.